In 2008, Congress directed the Treasury Department to commission a carbon audit of the Internal Revenue Code from the National Academy of Sciences. This was the brainchild largely of Representative Earl Blumenauer, who's a Democrat from Oregon. And the idea behind the proposal and the audit was that there are a number of ways in which the Internal Revenue Code affects greenhouse gas emissions, carbon dioxide and other greenhouse gases. And not as much is known about the extent to which the code has unfortunate global warming effects as one might like. Clearly the hope of the proponents is that once we get an informational handle on just which are the most offensive provisions in greenhouse gas terms, that Congress will respond to this information by either amending or repealing the offensive provisions, and there'll be a sort of greening of the Internal Revenue Code. I think there's some reason to be pessimistic as to whether or not Congress merely needs more information to do the right thing. And more than anything else, what makes me pessimistic is a story about what might be the most obviously environmentally offensive provision in the entire Internal Revenue Code, which is popularly, or maybe unpopularly, known as the SUV loophole. So the basic nature of the loophole is if you are a small business owner and you buy a vehicle to use in your business, if it's a luxury automobile, a relatively expensive car, there is a provision, Section 280 capital F for the tax junkies, which severely restricts your ability to claim depreciation deductions. For example, if you were to buy a Cadillac sedan for $60,000, the amount that you could immediately claim in the first year as a depreciation deduction, given that it's a luxury vehicle, and this is assuming you use it in your business, of course, would be only $3,000. But if instead you were to spend the same amount, $60,000, on a Cadillac Escalade SUV, which weighs more than 6,000 pounds, which is the magic number for purposes of the SUV tax break, you could actually deduct $32,000, a little more than half of the total cost in the first year. So more than 10 times the amount of the deduction. Now this seems like kind of the most politically objectionable tax break you could imagine. It's bad from just about every possible policy angle. In terms of what you might call internal tax policy, it violates the basic policy behind Section 280 capital F, which is that people shouldn't get business expense deductions for luxury personal consumption. In terms of energy policy, it encourages purchase of gas guzzlers and therefore increases U.S. dependence on foreign oil, which raises concerns about national security. And then from environmental policy, it encourages vehicles which emit a lot more greenhouse gases than lighter weight, more energy efficient vehicles. So it just couldn't be worse. And the question is, well, if it's so obviously awful, and one would think politically vulnerable too, because the general public is not particularly fond of people who drive SUVs, I think, in many cases. Why is it still there? Well, there's kind of a strange story. The provision goes back to 1984, when Congress first enacted the luxury automobile depreciation restrictions. And when they did that, they exempted vehicles that weighed more than 3 tons, 6,000 pounds. This was before SUVs became personal luxury vehicles of choice for a lot of folks. But of course what happened is the law stayed the same and the facts changed, or the SUV market changed. And by the mid-1990s, SUVs weighing in many cases more than 3 tons were very popular as luxury vehicles, but the law was still the same as it had been in 1984. So this tax break stayed pretty much under the public policy radar until in December of 2002, a story appeared in the Detroit News describing the SUV loophole, and it generated a lot of attention. Within just a few days, The story was picked up by the Wall Street Journal, the New York Times, NPR, the Los Angeles Times, ABC, World News Tonight with Peter Jennings. And it became really kind of a tax policy cause celeb, and the general reaction among both the public and the pundits was outrage. And everybody was predicting that the provision would rather quickly be repealed. So what happened? Well, in early 2003, President Bush proposed, and eventually Congress enacted, a substantial increase in a provision numbered Section 179, which is a provision which allows small businesses to claim immediate expensing deductions rather than gradual depreciation for a wide range of assets. SUVs were among the assets covered by this, but it covered a lot of other things as well. Now, there was nothing in this amendment that was specific to SUVs, but SUVs, so to speak, came along for the ride. So the strange result is, after this story broke about the SUV loophole, and after everyone predicted that it wasn't going to be long for this world, the actual legislative response was to quadruple the size of the loophole, which, of course, as you might expect, generated a lot more outrage. So what happens then? Well, the next year, Congress revisits this in light of the continuing or even increased outrage, and responds by reducing the loophole back to its original $25,000 in the case of SUVs. And lo and behold, most of the people who had been upset when the loophole was originally $25,000 were mollified by getting it back to $25,000 from its temporary expansion to $100,000. So this had absolutely, you would think, nothing going for it politically, and yet it's still there. So what's the moral? Well, the short version of the moral, and this won't surprise anyone who's been following American politics for the last few years, is that tax breaks, no matter how offensive they may be in policy terms, once enacted, are terrifically hard to remove. And put it this way, Congress is not going to become aware of any global warming promoting provision as a result of the upcoming carbon audit, which is more offensive than the one it's already aware of. And being aware of that really offensive one for at least about 9 years now, if Congress hasn't managed to bestir itself to repeal that, I'm not too optimistic it's going to bestir itself to repeal anything that's revealed by the carbon audit.